State Bar Council Law Academy. A very warm and splendid evening to one and all present here. I, Varsha R., a student of second year LLM, take this opportunity on behalf of the Karnataka State Bar Council Law Academy to welcome you all to the Day 8 session of the online lecture series on Civil Procedure Code 1908. I would like to commence with the verse 18 given by Lord Sri Krishna in chapter number 4 of Bhagavad Gita. He says, Karmanya karmayaha pashyet karmani cha karmayaha sa buddhiman manusheshu sayuktaha krishna karmakrit. One who sees inaction in action and action in inaction is intelligent among men, and he is in the transcendental position, although engaged in all sorts of activities. With this note, I, on behalf of the Karnataka State Bar Council Law Academy, extend my humble salutations to our eminent dignitary Hon'ble Justice N.Kumar, retired Judge of High Court of Karnataka. Welcome, sir. I would also like to welcome Shri Anil Kumar JM, Chairman of the Karnataka State Bar Council, Shri Gautam Chand SF, President of the KSBC Law Academy, all the members of the Karnataka State Bar Council, trustees of KSBC Law Academy, guests, advocates, law students, and all other attendees who are participating with great zeal. Before we get started, I request all the participants to post your questions or clarifications in the chat box, and sir will be addressing them during the question and answer session. And now, it gives me immense pleasure and jubilation to welcome back our distinguished speaker, Hon'ble Justice N.Kumar, who will be addressing on the topic, marking of documents and judgments in today's session. Welcome, sir, and the floor is yours.
Good evening to all of you. Yesterday, we were dealing with objection for marking a document which is not stamped or insufficiently stamped. Today, we will be looking into the objections regarding non-registration of a document, which is required to be compulsorily registered under Section 17 of the Registration Act. What is the effect of non-registration? When a party we are proceeding to prove his case, if you were to produce a document which is compulsorily registrable under Section 17 of the Registration Act and not registered, but still, if you want to tender the document in evidence and get it marked, if an objection is taken by the other side that it cannot be marked, it is inadmissible in evidence because of want of registration, what the judge is expected to do? What is the law on the matter? Now here, we must know, when we are dealing with the Stamp Act, Section 35 of the Stamp Act said, instruments not duly stamped inadmissible in evidence. So section said, if the document is not duly stamped, it is inadmissible. As opposed to that, Section 49 of the Registration Act speaks about documents which are not registered, but which requires registration. It only says what is the effect of non-registration of documents required to be registered. It says no document required by Section 17 or by any provision of the Transfer of Property Act of 1882 to be registered, and if it is not registered, shall affect any immovable property comprised therein. A document which is not registered will not affect the document which is the subject matter of the said instrument, or confer any power to adopt, or C, that is more important, be received as evidence of any transaction affecting such property or conferring such power unless it has been registered. So it does not speak about inadmissibility of document. It only says it will not affect the immovable property and it can't be received as evidence in any transaction. So the word inadmissible is conspicuously missing in Section 49. Why? We saw yesterday a document which is not duly stamped, if it is tendered in evidence, without objection it is marked, then though it was inadmissible, it has been admitted in evidence, and subsequently nobody can challenge the admissibility of the document. Court is bound to look into the document and grant whatever relief the party is entitled to, notwithstanding the fact that the document is not duly stamped. But in the case of registration, objection or no objection, the law says you cannot receive in evidence of any transaction affecting such property or conferring such power. So it is not a case of inadmissibility. It is a case of court not receiving it as evidence. But it is a proviso. That is very important. Provided that an unregistered document affecting immovable property and required by this Act or the Transfer of Property Act to be registered may be received. The main section says it can't be received. The proviso says it can be received. And for what purpose it can be received? May be received as evidence of a contract in a suit for specific performance under Chapter 2 of the Specifically Act. This is now also amended because in 2001, Registration Act was amended. Section 17, capital A was introduced. An agreement to sell is not a document which requires compulsory registration. It was optional. If under an agreement of sale, possession is delivered in part performance of the agreement of sale, then Section 53, capital A of the Transfer of Property Act gave a statutory right to the transferee to protect his possession even against the owner if he was ready and willing to perform his part of the contract. In other words, if possession is delivered as part of in part purpose of the contract of sale, and the transferee is ready and willing to perform his part of the contract, the owner lost his right to recover possession, even though no sale deed is executed. That was the effect. When that provision was misused post 1990 and 2000, when real estate started booming in this country, people did not get documents registered. They were happy with an agreement of sale, delivery of possession, construct the building, obtain a power of attorney, sell the property. There are huge losses to the revenue of the government. Therefore, the state law said, if there is an agreement of sale and possession is delivered in part performance, it requires to be stamped as a conveyance. That is the first step. So, stamp duty collection was made by introducing that clause. But the Parliament said in 2001, they introduced a provision to Registration Act, 17(1)(a), where they said if it is an agreement of sale and in part performance possession is delivered, that document requires to be registered. So therefore, it became a compulsory registrable document. Now the question was, if it is a compulsory registrable document and not registered, then it cannot be received in evidence. Received in evidence of what? Received in evidence of part performance. The benefit of Section 53A was available to the transferee. They said if it is not registered, the agreement doesn't become void. Agreement is not inadmissible, but you cannot have the benefit of 53A. But then what should happen to the document? That could be shown as a contract of sale. Still, a suit can be filed on the basis of such an agreement of sale for specific performance, but the fact that possession was delivered will make no difference, and the benefit of 53A is not made available to the transferee. Then B said, it can be received as evidence of any collateral transaction not required to be effected by registered instrument. In fact, this is the question which frequently arises in courts. A partition need not be in writing. It may be oral. If it is a palupatti, it does not require registration. If the memorandum of partition recording a past transaction, it doesn't require registration. So when a document doesn't require registration, then the law is, though a partition deed under which partition has taken place requires registration, and it cannot be received as evidence of partition, but it could be taken as an evidence of a collateral transaction not required to be effected by registered instrument. What are the collateral transactions? The document will be looked into to find out whether a partition was there, because partition doesn't require registration. If in pursuance of a moral partition, possession is delivered, that doesn't require registration. But if a partition takes place by metes and bounds, that requires registration. So that document cannot be looked into to find out which portion of the property has fallen to anybody else. But the document could be used for a collateral purpose of whether a partition took place in the family or not. In substance, if a document is not registered, it is tendered in evidence. If it is sought to be marked subject to objection, that it can be looked into for collateral purposes. So this is an aspect which a lawyer who is doing the examination in chief must bear in mind, and also the lawyer on the other side should bear in mind. You cannot confuse between Stamp Act and Registration Act. There it is inadmissible, you can't mark it. You can't look into it, court can't look into it. Import the document, only if you pay the duty and penalty, the court can look into it. Here, non-registration does not make the document inadmissible. Still, it could be received in evidence only for this limited purpose and not for the purpose for which the document is executed. So therefore, it is marked, it is looked into, but it is not registered. It is not going to affect any immovable property. And Section 53, a benefit cannot be given. And still, it is received in evidence to look into for collateral purposes. So this is an aspect which a lawyer should bear in mind when evidence is being adduced. The last thing which I would like to say for examination in chief is, please look into the amendments brought to these provisions in the Commercial Courts Act. It is unfortunate that the practice which is prevailing not only here, everywhere is, the plaint is converted into an examination in chief affidavit. Who does it? It depends on the person. Lawyer may do it, the stenographer may do it, the junior may do it. Who does, I don't know. All that is done is, the plaint or written statement is converted into an affidavit. Now, if the plaint contains pleadings, evidence, argument, statutory provisions, judgments, it also finds a place in the affidavit. Therefore, the affidavit in exam in chief will be as big as the plaint itself. It will be as big as written statement itself. This is not what the law expects. It is where I have a grievance. The judges were helpless. Because it is there, the other side will say, because it is there, I want to cross-examine. You want to cross-examine the argument? You want to cross-examine the statutory provision? You can't examine everything what is stated. Admitted facts need not be proved. Again, it is finds a place in the plaintiff. So that is one of the main reasons. Now, luckily, in the 2015 amendment, please look into it carefully. What they have done is, when I said there is no early judicial intervention in the court, now the court is expected to read the affidavit filed by the parties. If the affidavit contains arguments, unnecessary matters, a power is now conferred on the court to return that affidavit to the party, calling upon him to find, to say in the affidavit only the plea and the evidence. Remove everything else, otherwise I will not accept it. Or take the affidavit, read it, strike off the portions of arguments, statutory provisions, frivolous matters, extraneous matters, scandalous matters, and only keep what is relevant, which could be called as a plea and an evidence, and call upon the other side to cross-examine. For the speedy disposal, when examination took place on several occasions, it took several months. When the Parliament amended the law and said, all right, whatever you want to pay, file it in the form of an affidavit, so straight away cross-examination can go on. That is not, importance is not understood, not practiced. And I said it's a profession. If you want to do it in a very casual manner, how do you achieve higher status in the profession? First, you must learn to respect the law and why the law was made. If according to your law is not there, do something to get rid of that law. But keeping the law and say, I will not follow it. And keeping the law, you cannot do just opposite to what the law says. And that's precisely what is happening. If the trials are taking years and years, it is because of this want of professional approach. No, not respecting the law and taking it very casually. It's a profession. Please, no, it's a profession. And today you're all 5-year students. You are only equipped. Only thing is, you have to change your mental status. Don't look back. If you are senior, you will say, this is what my senior was saying. Those days are good. No comments on anybody else. Today we are carrying the chain. People want fast justice. Now law is suitably amended. And if you don't implement this law in a court of law, in your day-to-day work, how do you expect a change? Everybody wants a change and they don't want to change. There cannot be any change unless you change. Change should start from us. And unless you change, you cannot grow. Now, I will say this with conviction. It did not happen in 1999 or 2002. Please see the way the bar of the bench has not given due respect to the amendments carried out by the Parliament with the object of having speedy justice. Now, when we talk about Order 7, it starts with the word adjournments. Everybody is happy. If you want time, the court is not granting time, file an application Order 17, Rule 1. And adjournment is the birthright of a lawyer. If a judge doesn't give adjournments, then, especially in the rural side, pass a resolution for his transfer. And if an adjournment is there, you must see the face of the lawyer as if he got some advice. ಅದಕ್ಕೆ ನಾವು ಹೇಳ್ತಾ ಇರ್ತೀವಿ ನಮ್ಮ ಲಾಯರ್ಗಳು ಬಹಳ ಅಲ್ಪ ತುಚ್ಚು ಒಂದು ಅಡ್ಜರ್ಮೆಂಟು ಒಂದು ಎಕ್ಸ್ಪರ್ಟ್ ಎಂಟ್ರಿ ಮಾಡ್ರು ಕೊಟ್ಬಿಟ್ರೆ ಆಗೋಯ್ತು. That is not the entire profession. It's already in the beginning. Now, nobody has given proper attention to this Order 17, neither the lawyers nor the judges. And we are guilty of that. Today, my attempt is to show what 1976 the Parliament did, how a trial should go on in a civil court, what are the limitations, what you should do and what you should not do. Today, not one court, not in one case, these mandatory provisions are followed, and still everybody blames the CPC. In the Arbitration Act, it is said you need not follow CPC on the assumption that CPC is coming in the way. Today, in the latest 2015 amendment, the very same provisions of CPC are included. Then you have not read the CPC at all. Now let me see how many have read it, how many have understood the importance of it, how many has the mental status to implement it. Before you blame the judiciary, before you blame our existing legal system, and before you accuse that the existing system is not catering to the requirement of society, the CPC is coming in the way of speedy disposal. Order 17. Court may grant time and adjourn hearing. Court has the power. If court doesn't have the power, who else has the power? But adjournment cannot be given where we are asking. What the provision says is the court may, if sufficient cause is shown at any stage of the suit, grant time to the parties or to any of them and may from time to time adjourn the hearing of the suit for reasons to be recorded in writing. That's what I tell the judges. You have the power to grant sufficient adjournment, but it should be for a sufficient cause. Whether you have applied your mind, whether sufficient cause is made out, it should be made out from the reasons you are given it. Show me one case where this is followed. So and so ask for time, adjourn. So ask for time, adjourn. That's all. Why? Adjourn. That's all. The law says there should be sufficient cause. And when the judge is granting adjournment, he should record his reasons in writing so that anybody sees, they must know whether the judge has applied his mind, whether he is justified in granting time. Very casual approach. Then the amendment, further amendment said, provided that no such adjournment shall be granted more than 3 times to a party during the hearing of the suit. Here the hearing is, let us take it after the case is set down for trial. Not the first hearing, not the hearing after pleadings, not the hearing after framing of issues. When the case is set down for hearing, for sufficient cause being shown, court has the power to grant adjournment by recording the reasons, and such adjournment for a party cannot be more than 3. It did not stop there. When these provisions did not have the requisite effect, amendments were brought in 1999 and 2002. What is that amendment? Costs of adjournment. When a case is adjourned, please calculate the public time, public money involved in getting a matter before the judge, and after adjourn, the case going back to its original place. Nobody has calculated it. Legal audit has not taken place. You ask for adjournment, he grants an adjournment. It is not a mere matter between you. Public money is involved, public time is involved. Therefore, this provision was introduced. What is the cost of adjournment? In every such case, the court shall fix a day for the further hearing of the suit. Adjournment is all right, but it will fix a date of hearing, and shall make such order as to cause occasioned by the adjournment or such a higher cost as the court deems fit. There cannot be an adjournment without imposing costs. If a judge adjourns the case without imposing costs, he is not following the law. No discretion is given to the court while adjourning the case not to impose costs. See the word shall make a such order as to cause occasioned by the adjournment or such higher cost as the court may deem fit. If every adjournment is followed by a cost, take it from me, the litigation period will come down radically by half. You want adjournment, it is for a cost. Then before asking for adjournment, you have to think twice. Assuming the lawyer asks for adjournment and the cost is imposed, the client will ask, why should I pay? I was ready. Why should I pay cost? And if the lawyer has to pay, how much he will pay his cost? That is the object of this amendment. To see speedy disposal, to see unnecessary adjournments are not sought, and judges compelled to give reasons for adjournment and impose costs. It is not a mere cost between the parties. Public money, public time, whole system will go away if it is not properly followed. Having said this, there is a proviso. You make a request, court grants adjournment. Sufficient cause is paid out, 3 adjournments, cost is also paid. This proviso is taken from the Criminal Procedure Code, which was found in section 309. Today, even a sessions case is not conducted in the session. Forget about the civil case. That is the advancement we have made in our judicial system. Blaming the procedural court, breaking the court, but not following the law. What does the proviso say? When the hearing of a suit has commenced, till it is commenced, it is all right. When does the suit commence? Hearing of the case, you put the witness in the box. You have put the test in the box. You have filed the affidavit in exam in chief. Documents are ready to be marked. And you start. When the hearing of the suit has commenced, it shall be continued day to day until all the witnesses in attendance have been examined, unless the court finds that for exceptional reasons, you see the word, there they said sufficient cause, here they said exceptional reasons, to be recorded by it, the adjournment of the hearing beyond the following day is necessary. Please tell me, in our course, though the law expects day-to-day hearing, till the people, witnesses or attendants is completely examined, and time is over, it should be taken next day itself. If it is to be taken day after tomorrow, court has to record the reasons. Which other procedural court provides for such a speedy remedy? People say, we don't want to follow CPC, we don't want to follow Evidence Act. What is the better law you have? This is the provision is there from 1976. If this is followed, how much time a litigation will take? 2 days, 3 days, 4 days, 5 days, 1 week, be over. But today it is taking 5 years. 4 questions is put in cross-examination, adjourn. 2 months, 3 months to adjournment. People have forgotten what they have said. In installments, cross-examination. That is the sincerity, that is the professional competence of the members of the bar. And the judges are also blindly granting adjournment without knowing their responsibility. So the law says, once the trial commences, it should be on a day-to-day basis until all the witnesses in attendance are examined. Please see the second one. No adjournment shall be granted at the request of a party, except where the circumstances are beyond the control of the party. So what is a sufficient cause? What is an exceptional cause? It should be something which is beyond the control of the party, not otherwise. I have to go there, somebody in the house is well, my driver is not well, my driver's wife is not well, my maid servant did not come, my junior has not come, my typist has not come. Anything is a good reason for not going on with it. Pardon me for saying this, what the Civil Procedure Code says from 1976. See, the fact that the pleader of a party is engaged in another court shall not be a ground for adjournment. A battery of junior lawyers have that object is to go to the court, say my senior is held up, he is on his legs, and therefore he is not able to come. Granted adjournment. Law says the fact that the pleader of a party is engaged in another court shall not be a ground for adjournment. Anybody is respecting it? Still worse. Where the illness of a pleader or his inability to conduct the case for any reason other than his being engaged in another court is put forward as a ground for adjournment, the court shall not grant adjournment unless it is satisfied that the party applying for adjournment could not have engaged another pleader in time. This is the law. Whether you are able to follow it or not, don't blame the law. Especially in rural areas, mafufal areas, a big lawyer, his daughter's marriage is there. So till the daughter's marriage is over, adjournment, because his marriage in his house. Or he says, I had been to doctor. He wants me to come and have an operation. He has given a date in 3 months thereafter. So this 3 months case is adjournment. After operation, another 3 months is catered. Virtually that case comes to a stand. And you are blaming CPC. How is CPC responsible? Therefore, I said not following CPC, the cause for adjournment. If I say that, people get upset. He has no heart. Or then don't blame the system. If the court proceedings have to adjust to the commitments, requirements of each lawyer, and any day, given a day, in a city like Bangalore, there will be 1,000 lawyers appearing in a particular court. How will the court proceedings go on? Please understand. You have to run a system, a judicial system. Access to justice is a fundamental right. Speedy justice is a fundamental right. Everybody is talking about constitution. Everybody is talking about fundamental rights. Everybody wants change. Who should change? If you want to change the law, law is changed 76, 50 years back. But we have not changed. There is no necessity for us to change. Follow the law. You are not doing it. See another thing. Where a witness is present in court, ನಮ್ಮ ಅನುಭವ ಕೋರ್ಟು ಫೈಲು ಆ ವಿಟ್ನೆಸ್ ಕೊಟ್ಬಿಟ್ಟು ಪಾರ್ಟಿಗೆ ಕೋರ್ಟಲ್ಲಿರೋ ಕೇಸ್ ಕೂಗಿದಾಗ ಹೇಳು ನಮ್ಮ ಲಾಯರ್ ಬರ್ತಾರೆ ಅಂತ. ಇದನ್ನ ನೋಡಿ ಏನ್ ಹೇಳಿದಾರೆ ನೋಡಿ ಪಾರ್ಲಿಮೆಂಟ್ ಅವರು. ವೇರ್ ಎ ವಿಟ್ನೆಸ್ ಇಸ್ ಪ್ರೆಸೆಂಟ್ ಇನ್ ಕೋರ್ಟ್ ಬಟ್ ಎ ಪಾರ್ಟಿ ಆರ್ ಇಸ್ ಪ್ಲೀಡರ್ ಇಸ್ ನಾಟ್ ಪ್ರೆಸೆಂಟ್, or the party or speeder, though present in court, is not ready to examine or cross-examine the witnesses, the court may, if it thinks fit, record the statement of the witness and pass such orders as it thinks fit, dispensing with the examining chief or cross-examine the witness, as the case may be, by the party or speeder not present or not ready as aforesaid. If any judge were to apply this, will the members of the bar leave him alive? Motives are attributed to him. He is personally interested. He has no patience to wait for the lawyer. Patience to wait for the. He wants speedy disposal. And one say you want speedy disposal. If the judge follows the law, you counsel him. This is the procedure prescribed in the Civil Procedure Code. These are the amendments which were brought in 1976. These are taken from section 309 of the Criminal Procedure Code, which is the procedure provided for Sessions Code, Sessions cases. My young friends, please understand. Don't look back. Don't try to find out what that man did. This is the law. You are all 5 years law students. You are all the lawyers of 21st century. You have no patience. You want speedy disposal. If you want speedy disposal, rise to the occasion. Possess the competence, courage, capacity to follow the law in letter and spirit. Conduct the cases in the manner prescribed under the Civil Procedure Code. Automatically, the system becomes effective. There is nothing wrong with the laws. There is nothing wrong with the judicial system. It is the persons who are running the show. They don't have the mind. They don't have. I don't say they don't have the capacity. They don't have the mind. So what is required today is, at least in the present day generation of lawyers, there should be a change of not heart, change of mind. If it is done, I'm sure with the laws which are in force, you can achieve greater success. So therefore, amendments are brought in 76. Amendments were brought in 1989. Amendments were brought in 2002. But it is in the book. Nobody looks into it. Nobody wants to follow it. And if anybody insists on that, he is called a cantankerous lawyer. This is where we stand. Therefore, the Civil Procedure Code is a piece of legislation which post-independence we are unable to have a substitute. All that we have done is some superficial corrections here and there. Even that we are not following. And certainly Civil Procedure Code is not the reason for delay in disposal of cases. It is the knowledge of law, the courage to uphold the rule of law, courage to implement the rule of law in letter and spirit, which is the need of the hour. And I have no doubt in my mind, the present generation do have that capacity. Only thing is, they should make up their mind. If they change, if they make up their mind, in days to come, this speedy justice is possible within the existing system without doing any changes in the existing system. So this is about the trial. After the trial is over, the next stage in a litigation is arguments. Let me tell you my experience. I have also done it and people used to do it. In those days, the Xerox copy was also out there. Arguments are heard only in the afternoon. So we used to go and pack the entire one-side table with 20 books and threaten the judge, oh, I want 3 days, I want 4 days, I want 5 days. That poor fellow, what will you do? If you can find an opportunity, you will do it. This tendency of threatening judges with books and saying it will take up 4 days, 5 days. Why will it take 4 days, 5 days? Because you don't go on with the case. Only when the judge compels you to do it. How do you do it? Then you take out the pleadings. Start reading the pleadings. Especially after 2 o'clock, if you had a good food, and if you are reading the pleading, it will be like music. You will be sleeping and you will be reading. Reading the pleadings, reading the evidence, reading the documents, reading the judgments. It goes on. That anybody can do. Why do you need a lawyer? Anybody who has English knowledge can do this. What is the greatness about a lawyer? The greatness about the lawyer is you have drafted the pleading. You have looked into the written statement. You know what are the material facts that are admitted and not admitted, and the issues have been framed. You have led oral evidence and documentary evidence. And you know the law on the point, statutory provision as well as the case, judge-made law, interpretation of the statute. See, you should be able to stand up and tell the judge in half an hour, look, this is the case of the plaintiff. This is the case of the defendant. These are the issues framed in this case. To prove my case, I have examined 2 witnesses, 3 witnesses. I rely on so documents. This is what he has done. So the point for consideration is this. You must be able to go straight to the point. If necessary, after the issues are framed, when you are arguing, you have to argue by issue wise. You say issue number 1, burden is on me. The issue number 1 arose because of this plea I have taken in the plaint. This plea is traversed in the written statement by this way. Read the plea and read the written statement, the issues. Then you say, this is the documentary evidence I have got. If necessary, read those documents. If you want to rely on the oral evidence, make a underline, read those. And then say this particular issue is true. If a judge is alert, he will also make a note. Where is the plea regarding this issue? Where is the objection? And then what is the documents on which he relies on? Where is the oral evidence made? Very easy. Otherwise, simply standing and go on, arguing, reading, it will never. It's not a professional. If you call it a professional job, maybe pleadings may be so much, so many case law is there, so much evidence is there. You are an expert in the field. You are a professional. You will just go and have your hand on the exact point. And when you project it, it gets into the judge. If you are reading it, he is sleeping. You will never know what it is. Then one fine day, he will get up at 4 o'clock. Again, he will do the same exercise which you have done. Whatever he done, finished. Now, 76 amendment also provided for written arguments. So after this oral argument, a month time is given to written argument. God only knows what the written argument contains is what you have argued or new case and how much you expect a judge to read. So this is one of the reasons why in the end of the day when judgment comes, sometimes you will be wondering in which case he has passed it. And you will say he has not considered this point, he has not considered this judgment, he has not looked into this. They are all ground for appeal. Tomorrow I will talk about the appeal. It's not like you can make out a very good ground. No judgment is perfect. Let me tell you, as long as judges are human beings, no judgment rendered by them can be 100% correct. It is not correct. And it need not be 100% correct also. What we are talking about is substantial justice. And lawyers are experts in finding out faults. So they do their job. They will certainly find out faults. And that is the ground on which they file appeals. This is all professional. But in the end of the day, how does it serve the cause of justice? So therefore, when you are arguing, you must read the papers in the house. You must make notes. You must have only, if you, on any point today, if you go to the computer, you will get 100 judgments. Ask your junior to take out copies. He will take out copies. He will keep it on the table. On a particular proposition of law, how many judgments you want to say? And you slip into the judgments from back. Earlier judgment is cited here. Both these judgments are cited there. Like that, only repetition. See, you have to pick up one judgment which is helpful to you. Concentrate on that. I tell the judges, if you read 90 judgments cited, and only after reading you will find out 89 judgments are not relevant. That is how time, judicial time is wasted. The judge time is also precious. And you are here to assist the judgment. Judge is writing a good judgment. Come to the point. Give him few judgments. Ask him to underline some portions. Read the whole judgment or read the relevant portion, not head notes. Then only probably a proper assistance would be there to the court, the judge, to pass an order. For time constraints, I will stop there. Now, after all this, case is reserved for judgment. So judgment is to be delivered by a judge. So what is that he has to do? I was told some of you are interested in becoming judges. You wanted to know how to write a judgment, and you're all experts in criticizing judgments. But to write a good judgment is not that easy. Now, judgment writing is an art. It is an intellectual property of the judge. Though you assist him, pleas are by you, argument is by you. In the end of the day, how he appreciates the material on record and renders the judgment, that is purely his creation. Creation based on material. He can't go on writing something which he wants. It should be based on material. Now, as far as writing judgment is concerned, in the entire civil procedure code, you do not find a provision prescribing how a judgment to the trial court is to be sent. That is, a judgment in a suit is to be written. But the civil procedure code provides how a judgment of a first appellate court should be returned as contained in order 41 rule 33 of the civil procedure code. Therefore, the beginners who get into the judicial system as judges, civil judges, they have to learn this art of writing in the judicial academy, we teach them, or through their seniors, of course, also because of their intelligence. Now, when you want to write a judgment, trial is over, pleadings are there, evidence is there, documents are there, judgments are given, textbooks are there, all is there. This is the material. From this, you have to write a judgment. By mere reading, you can't write it. When you read, you must understand. You must be able to absorb what is required and what is not required. And there are well-written, well-known principles which a judge must know if you have to produce a good judgment. So what are those unwritten laws, but well settled, which a judge must know, possess, and follow? The first and the foremost is, you have a plea and evidence is given. Therefore, it is said, when you are reading the pleadings and the evidence, the principle you must know is, any amount of plea, beautiful Shakespearean language it is written, but there is no evidence supporting it. What is the use? Any amount of plea without evidence is of no use. That is the first principle. Beautifully written plea. When it comes to evidence, big zero. That plea is of no use. Similarly, you have adduced so much evidence, voluminous evidence, but supporting plea is not there. Without a plea, if you adduce evidence, it is also of no use. Any amount plea without evidence, any amount of evidence without a plea is a big zero. That a judge must keep in mind when he is reading the pleadings and proof. When he reads the plea, he must find out where is the evidence. If there is no evidence, the plea has no value. And without a plea, he looks to so much evidence, supporting plea is not there. All that is not valid is of no use. Secondly, in the pleadings, a case is made out. Partially, the case is admitted. Then don't expect the plaintiff to prove that, because the law is what is admitted need not be proved unless the court wanted him to prove it. Generally, when you look at what are the admitted facts, what are the disputed facts. So admitted facts need not be proved. So don't look into where is the evidence. If the lawyer says, because the written statement is admitted, if they have simply led evidence only on disputed facts, and when he argues, look, this is what is admitted, you can't expect him to produce evidence. You can't ask me where is the evidence. Not necessary. Admitted facts need not be proved. Then it so happens when you're arguing, the lawyers put forth the argument in a very powerful manner. Why? In the cross-examination, he has taken a very good admission, a stray sentence, an admission, according to him, is sufficient to destroy his own case. Is it the law? If the witness is natural, if he is not tutor, especially when he is coming to the court for the first time, he will be seeing that atmosphere for the first time, he is cross-examined for the first time, there is a judge waiting and watching his demeanor. Sometimes it so happens he is not able to understand question, he may give some answers which are damaging. An admission, a totally opposed to what his case is. But the law is well settled. A stray admission in evidence cannot be blown out of proportion to throw away a case. Yes, keep that admission. Look at the other portions of the evidence. And if those evidence outweigh the stray sentence, you can always say, yes, here is the sentence, a stray sentence. But it has to be read along with the other evidence. And I feel this is a stray sentence, and therefore it has no value, and you can proceed. No, you must know that law. The argument is, look at this sentence. He has said so, finished. The evidence is 40 pages. Cases on different aspects. One admission can't throw away a case. Of course, it is dependent on the facts of the particular case. Now, another good principle is, the admission may be in writing, admission may be in evidence. It is settled law, if an admission is in writing, you cannot dissect it. Either you take the whole admission or you reject the whole admission. You cannot take one sentence out of context and say here's an admission. But in the case of oral evidence, as I said, you can dissect that one sentence. So an admission in writing is to be taken as a whole or rejected as a whole. An admission in box could be dissected, and depending on the facts of the case, you can do it. And I said, when you read evidence, I told you, examiner chief exhaustively repeats, and he also cross-examines. Point in issue is something. Most of the time, entire cross-examination evidence is totally on irrelevant matters. If the judge were to obstruct being active, he is receiving it. If he is sleeping, full scope and all sorts of evidence is given. So the judge will realize only at the end of the day when he is reading what is the case, what is his evidence. Therefore, it is said, a judge should know how to separate the wheat from the chaff. Only chaff will be there. You have to separate the wheat. That's an art. That is possible only when you know the fact. When a judge has a complete grip over the subject, he has marshaled the facts, he knows what is the matter in controversy, he knows what are the admitted facts, and what do you mean by relevant evidence, what do you mean irrelevant evidence. If all these concepts he is well aware, with the assistance of that, he should be able to separate the wheat from the chaff. That's an art. Then we have an Evidence Act. Evidence Act says facts judicially noticeable need not be proved. So don't expect anybody to prove it. Act itself, Evidence Act says these are all taken for proof. So that is, no fact of which the court will take judicial notice need be proved. So don't look to evidence. And then Section 57 of the Evidence Act speaks about facts of which court must take judicial notice. Everything is enumerated. If it falls in that, no proof. Law says it is proved. And yesterday I said facts admitted need not be proved. Section 58. So these are the principles which a judge must bear in mind. And with that in background, he must start reading the judgment, reading the material on record. So how do you do it? From where you start, where you end, where you stop. The way in which a judge has to read the material on record is, first you read the pleadings. Take a red pen, take a blue pen. When you read the written statement, it will come out what are the admissions. All admissions you make green ink. Then what are the denials, you make it in red ink. When you dictate the judgment, you can confidently say these facts are admitted. You can say this is the fact in dispute. If you don't make a mention, again, you will be wasting time. Then you come to the issues. Now you know what is admitted, what is denied, and find out whether the issues you have framed it or somebody else has framed it. If the issues are properly framed, does it require any amendment? Has any issue to be deleted or any additional issue to be framed? You make up your mind that calm because you have conducted the entire trial. Then after looking at the issues, then you will find out on whom the burden of proving that issue is there. Section 101 to 106 of the Evidence Act gives a various facets of this burden of proof. That law you must know. It will not be a reading. You must know Evidence Act. What do you mean by burden of proof? What do you mean by onus of proof? What should be proved by the plaintiff? What can be inferred? And what should be proved by a person whose knowledge is there and how the issue is framed? And then you can search in the material whether the plaintiff has discharged that burden. Especially when you look into this, initial burden or burden of proof always doesn't shift. It is always on the plaintiff. Plaintiff has entered the witness box and he has given evidence. You read it. So when you read only his evidence, you may get a feeling, oh, he has done it. Then the onus of proof shifts to the defendant. Then you have to look into his evidence. When you look into the evidence, you may also get a feeling, oh, he has discharged it. If both have discharged it, what is that you are going to do? Once he has discharged his burden, again the onus shifts here. Then you must say what he has said. So this exercise goes on. And at the end of the day, neither the burden of proof nor onus of proof is relevant. Both of them have adduced evidence. It is before the court. Now the stage has come for you to read that evidence, appreciate it, and then record a finding. And that is called evidence. Evidence is defined in the Evidence Act. Everybody talks about it, nobody looks into that definition. Evidence means and includes 1. All statements which the court permits or requires to be made before it by witnesses in relation to matters of fact under inquiry. Such statements are called oral evidence. Yesterday I told you what is oral evidence. He has entered the witness box, administered oath, and he has seen what he has seen. He has spoken to what he has seen. He has spoken to what he has heard. He has spoken to what he has perceived. That is oral evidence. Then in addition to oral evidence, documentary evidence is produced. All documents, including electronic records produced for the inspection of the court, such documents are called documentary evidence. Documents are produced, documents are marked subject to objection, and the objection is argued, and the judge knows what that means. Then you have to decide whether the document is admissible, if the objection is valid, if the document is proved, admitted is all right, marked is all right, that is no proof. If the document is disputed, party has to adduce evidence to prove the document. If the execution is in dispute, execution is to be proved. Execution is admitted, but the contents are not admitted, and they said it is obtained by fraud, undue influence, misrepresentation, whether any evidence has been given to that effect. If the document is produced and the author that is disputed, the author of the person document has to be examined. Only then that it can be said the document is proved. So therefore, oral evidence, documentary evidence, and in the context of what is called as facts and issue. You have produced so much evidence, but that evidence must be reasonable and it should be related to the facts and issue. It means it includes any fact from which, either by itself or in connection with the other facts, the existence, non-existence, nature, or extent of any right, liability, or disability asserted or denied in any suit or proceeding necessarily follows. That is a fact and issue. And therefore, in the end of the day, you have the pleadings, you have the oral evidence, you have the documentary evidence, judgment, law, and the judge should be able to appreciate the entire material of the court. So what do you mean by appreciation of evidence? See, the evidence does not purport to lay down, Evidence Act, any rule as to the weight to be attached to the evidence when admitted, nor is there any such possibility. Proper appreciation of evidence is a matter of experience, common sense, and knowledge of human affairs. That is right. We have hierarchy of course. 5 years law students straight away come together. They're brilliant. What is their experience? What is their knowledge of human affairs? That they learn Therefore, appeals are filed. Second appeal is there. They are bound to commit mistakes. And it should be justice is to be done. Therefore, an experienced man sits in the higher level. A further experienced man sits at the top. So with their experience, with the knowledge of human affairs, they also look into the same facts, bear the law, and if there's an error to be made, a correction to be made, they do correct it. So appraised evidence is a very important aspect, a role of a judge. It requires experience, common sense, and knowledge of human affairs. Then each of the case, there are no two cases which are alike. Take it from me. We argue a similar case, identical case. There is nothing like an identical case. There is nothing like a similar case. No two cases are not alike. Each case presents its own peculiarities and common sense, and sureness must be brought to bear upon the facts elicited in every case, which a judge of facts in this country has to weigh and decide. It is not the volume, it is the weight of evidence which is to be taken. Evidence Act nor any other act lays down any law governing the question which statement of a witness should be believed or should not be believed. There is no law. The question depends upon many circumstances. It is impossible to lay down hard and fast rules. The law has left it to the court to decide. That is why it is common sitting on the floor. Only when you sit in the chair, when you are confronted by so many things, then you must deliver the goods. And judge is trusted and complete discretion is given. The law has left to the court to decide whether the evidence should be believed or not believed. And if believed, what weight should be attached to it, what should be given to it. These matters have been left at the sound discretion. That's what we call discretion, a judicial discretion. Although efforts have been made by mathematical writers to formulate rules for determining moral certainty, it is obvious that no satisfactory system can be devised for weighing evidence and drawing conclusions. You have so many books. Authors of the books have no personal experience. It is there what they feel is right. The effect of evidence must necessarily be left to the discretion of the judge. It depends upon his social background. It depends upon his economic background, his educational background, strata of the society from which all this will go into that when he is appreciating the evidence. It can't be ignored. It is not a mathematical precision. It is not a computer. He is a human mind. He has own likes and dislikes. We can't take it. You have to accept it. It is impossible to reduce men's minds in the same standard. 5 fingers are not alike. Nobody is alike. You cannot expect every judge's mind to be alike. Then they are not judges. Then there is nothing to be judged. As bodies are not alike, how do you expect the minds to be alike? It is impossible. But you must ensure that they are not eccentric or extravagant. Some principles are there. You have to be within those principles. And the most important thing is evidence is to be weighed and not counted. How many pages of evidence, how many number of witnesses he has examined has no bearing. What they have said, is it relevant? Can it be believed? Does it carry any weight of conviction? That is to be looked into. Not the number of pages of evidence recorded. Number of witnesses examined in the case is totally irrelevant in deciding a case. And therefore, the judicial training and experience, wide knowledge of men and things is a must. So after seeing all this, in the end of the day, the court has to say whether the case is proved or not. That is the job. That is the decision. Now, the Evidence Act has not kept anybody in doubt about this. The Evidence Act defines what do you mean by proved, what do you mean by disproved, what do you mean by not proved. Proved says a fact is said to be proved. That is the question before the court. A fact is said to be proved when, after considering the matters before it, the court either believes it to exist or considers its existence so probable that a prudent man, the test is that of a prudent man, ought, under the circumstances of the particular case, to act upon the supposition that it exists. There is no guarantee that every judge has a judicial mind. There is no guarantee that every judge is a prudent man. But what Evidence Act says is, what is expected of a prudent man is sufficient. After reading the whole material on record, if you feel, keeping in mind the principles governing this, yes, I feel it is good. I feel it is true. I feel this exists. That's the end of the matter. That's the end of the matter. Beyond that, nobody can expect anything else. But without reading the paper, if you read only pleadings and write a judgment, it is wrong. Because you saw the people when the evidence was recorded, on that basis, if you do it, it is wrong. You read something in the paper and on that basis, if you write a judgment, it is wrong. Your own likes and dislikes, your own ideology, on that basis, you write it is thoroughly wrong. But if you do this exercise, read the pleadings, read the oral evidence, read the documentary evidence, look into the statutory provisions, look into the case law on the point, and you are understanding. And then if you honestly feel, bona fide feel, yes, this is proved or not proved, that's the end. If you say it is proved, that's the end of the matter. So how can there be similarity between judgment and judgment, between judge and judge? And that is why we find so many judgments. We have seen in the Supreme Court, there are 32 judges. You see how many types of judgments come. Don't blame the Supreme Court. They're all human beings. Their background, their understanding, their learning, their specialization in a particular field, the arguments which are canvassed before him, their likes and dislikes, over, we may say, I am neutral, I am not influenced by this. We're all human beings. Therefore, you find all this. One person says it is proved, another person is not proved. Then it also decides disproved. When a person comes to the court, he has to prove his case. There is no obligation cast upon the defendant to disprove his case, but he takes upon the responsibility. Yes, it is permitted. A fact is to be disproved when, after considering the matters before it, the court either believes it that it does not exist or considers its non-existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it does not exist. Not proved is a fact said to be not proved when it is neither proved nor disproved. Proved, not proved. Proved, suit decreed. Not proved, suit dismissed. Disproved, suit is dismissed. The defendant did not take the responsibility of disproving the case. If he is able to show that the case is not proved, he succeeds. Sometimes over enthusiasm, sometimes they have material. It is placed and shown. Not only he has not proved his case, I will disprove his case. He's a blackguard. He's a false. He's a fraud. I will show these documents. And then a judgment is taken. So proved, not proved, disproved. When a judge says it is proved, it is proved. When a judge says it is not proved, not proved. When he says it is disproved, it is disproved. If you are agreed, you have to prove nothing. Therefore, in the course of all this, one principle which a judge should bear in mind on the civil side is preponderance of probability. There is no section which says so. For a period, we have said, in criminal cases, the Indian jurisprudence is, in criminal cases, if a person is to be convicted, there should be proof beyond reasonable doubt. That's one concept. But in civil cases, no, we don't insist on the strict proof. Preponderance of probabilities is more than sufficient. And that's why it is proved, not proved, disproved is there. And the court feels, yes, it is proved, it is proved. Now, once you come to this conclusion, sometimes people will say, you already made up your mind. Just to make up your mind, that's the job of the judge. Some people will make up their mind immediately. Some take their own time. So lawyers should not fix time limit when the judge should make up his mind. So once you have made up your mind, you are ready, you know in which way you have to go, then you have to start dictating the judge. I said, nobody will write it today, dictating. So therefore, you have at some stage you have to make up your mind. Otherwise, you will be a doubting Thomas. Oh, what they said is correct. Oh, what they said is correct. Again, what they said is correct. It's all right what you are going to say. So you have to come out with a judgment. You can only say he is right, he is right, he is right. What is right in that case? So therefore, when you start dictating the judgment, you must be clear in your mind about what you are doing, in which direction you are going, and then you have to set out. As I said, there is no law which governs it, but first look into the cause title. Make sure that the party in the suit before you are their name finds a place in the cause title. And court number is also properly mentioned. When you have two stenographers attached to a judge, sometimes it happens. This case, cause title will be in another court and that court, and lawyers will make a big galata. It's all sometimes we trust some people, sign it, and this is what happens. So therefore, a judge should be careful, should make out whether his court is correctly mentioned, whether the cause title is properly mentioned. Then he must set out, not repeat what is there in the plaint. Don't bring their thing. Otherwise, if you repeat what is there in the plaint, it is the language of the plaintiff lawyer. If you want to repeat what is there in the defendant, it is the language of the defendant lawyer. And then it will be your language. So 3 languages. No. You have read the plaint. You please put up, remove all extraneous matters. Take only please, dictate it. Then you dictate the written statement. Issues are already framed. You put the issues. Then you must say, plaintiff, in order to prove his case, has examined how many witnesses? PW1, PW2, if possible, give the number. And he also has produced 10 documents, exhibit P1 to P12. Then the defendant has examined himself as DW1 and he has examined 2 witnesses as examined DW2 and 3. And he relies on 28 documents which are marked as exhibit D1 to 28. Then you must say, the learned counsel of the plaintiff in support of his case contended. If you have made notes of what he has said, and if you remember it, briefly you must state what the case of the plaintiff as put forth by the lawyer in the argument. Then you must say, controverting this document, the defendant's counsel submitted as under put it. So everything is in order. Then you say, plaintiff in his exam chief has said so. He has been cross-examined. In the cross-examination, there's an admission like that. He has taken this answer. And if you are satisfied that nothing is elicited in cross-examination, if you say the plaintiff has withstood the test of cross-examination, no damage is done to it. And then also they rely on the following documents which are disputed, not disputed, disputed, proved, not proved. And this is the content of the document. And this is the case of the defendant. And then you have to record a finding whether that particular fact is proved or not proved. And at the end of the day, depending upon the findings of the issues, you have to ultimately say suit is decreed or not. Suit may be decreed as paid for, suit may be decreed partially, suit may be dismissed also. And cause or no cause. This is broadly the framework of a judgment. This, any amount of teaching is of no use, any amount of reading is of no use. Like a child, when it starts walking, it will fall, get up, walk, get up. Therefore, with that confidence and with that responsibility, when you start writing judgments, over a period of time, you will learn that art. The experience shows you the way. At the same time, experience shows you this thinking process in the mind also goes on getting formulated. And as days pass by, you have a mastery over this art of writing judgment, and you can produce better judgments in course of time. Thank you. Any questions?
Thank you, sir, for your valuable inputs and for your significant contribution. I now request Mr. Madhusudana Reddy, advocate, to take charge of the question and answer session. Over to you, sir.
Thank you, Varsha. Thank you. So, what is the difference between compromise in a representative suit and in general suits?
See, they're all big fields. Representative suit means there is no personal interest involved. Public interest is involved. Order 1 Rule 8 specifically, in other words, it's a public interest litigation. Public litigation is filed invoking Article 226. The Civil Procedure Code of 1908 also provides for public interest litigation. And that is contained in Order 1 Rule 8. Please, that's all. Representative suit. It is not filed for enforcing his right. It may be a right which is commonly enjoyed by a group of people, or it may be a right belonging to the public.
Thank you, sir. Sir, I just take an offline question. What is proposed defendant and pocket defendant?
I don't know about pocket defendant. I don't know. There's something peculiar I'm hearing for the first time. Proposed defendant means a necessary party or a proper party is not made a party. An application is filed to implead a person. Till he is impleaded, he is called a proposed defendant. He is proposed to be added as a defendant. Only when the application is allowed, he will be made a party. Till such time, from the moment the application is filed, till that application is allowed and implemented, he is called a proposed defendant. A proposed party or proposed defendant. I have no idea about this pocket defendant.
Sir, can a registered partition deed be challenged based on unequal shares and on undue influence?
Yes, certainly. Certainly.
Sir, can a sale deed registered by a GPA holder without the permission of the owner can be cancelled by court?
Power of attorneys could be cancelled by the executant. Necessity for him to come to court. When a party can cancel a power of attorney, why do you come to the court for cancellation? He is an agent.
No, what they are asking is the question is whether a GPA holder, I am a GPA holder, but still should I get the permission of the owner to sell the sale deed? Is the question.
Not necessary. That's a power of attorney. You are his agent. He has given you the power. Sell it.
Sir, how to prove a will where attesting witnesses are dead, sir?
You have to examine their in-laws or any other person who is acquainted with the signature of the attesting witness. That fellow will come and say, not about the will. He will say, I know the signature of this attesting witness. I am clear. This is his attesting witness. That's all.
Sir, why arbitration award be stamped? Is it not the burden on the party who obtain an award?
Challenge it. That's the law. Challenge it. I told you the fiscal legislation, government wants revenue. In the civil code, you pay court fee, stamp duty. In arbitration, there is no stamp duty. Therefore, at the time of decree, at least when you have a decree, pay the stamp duty. That's the law.
Sir, what is the remedy if judge adjourns more than 3 times?
That's what I said. You should stand up and show to the judge, this is the law, and what you are doing is contrary to law. That is not expected of you. If you have some self-respect, obey the law. You must tell them. You must stand up and tell them.
Sir, so admissions contrary to law, are they admissible?
Admissions are admissions. If the court acts on it, it is an admission. You cannot compel him to act on it. If he is not happy with the admission, I showed his provision. He can say, come on, prove it.
Hey, what he says is contrary to law. I don't know what is that admission contrary to.
You may say, yes, I have executed a sale deed. It's an admission. But sale deed is not registered. Nothing happens. Section 49. People today have forgotten the difference between an agreement of sale and a sale deed. In the court, I have seen people who have put in 10, 15 years of experience telling me he has executed a sale. When I asked them to give a copy, they gave me the agreement of sale. According to them, agreement of sale is the sale deed.
Sir, what is issues in fact and fact in issue and question of law and question of fact? Is a DJ exam question itself.
Fact in issue is that is defined in the Evidence Act. That is the point that is to be resolved in the suit. Issue of law means, issue of law and issue of fact means an issue which will be decided on the evidence. Issue of law is purely a question of law. So issue of law, issue of fact, fact in issue. Fact in issue is the dispute which is before the court, which the court has to decide. Issues may be issues of fact and issues of law. And issue of law is purely a question of law. And issue of fact is a purely question of fact.
Sir, see, portion of the document only is admitted, like let's say name and the address. Can the entire document to be marked?
It all depends on what purpose he has been. See, document is marked. How much of it you read is left to the lawyer and the judge. There is nothing like marking the full document or half the document. That happens when, under section 145, if the person in the witness box is cross-examined and he has made some statement in writing, he is saying something in the witness box, contrary to that. Then, for the purpose of contradiction, if you want to use the document, you show him the document. That document may be 4 pages, but you are not interested in that. There is 2 lines, which is relevant, and he has given evidence on both contrary to that. Then you mark only that portion. Otherwise, the judge will not know why this document is marked. That's all the reason.
145 Evidence Act, no, sir?
Yes, 145.
Sir, manner of writing judgment is applicable to writing an award also in arbitration?
Same thing. You call it an award, here you call it an award, there you can call it a judgment, they say award need not be as lengthy as a judgment. People who are saying yes are all old timers, because under the old Arbitration Act, an arbitrator need not give reasons. That was the law. Therefore, anybody can write a judgment. You pay this money, that is sufficient. And we saw how it was abused. Therefore, in the 1996 Act, they said as a rule, judge award should give reasons. But if the parties agree no reasons being given, they take the risk. So when you say you give reasons, that's the same thing happens in the judgment also. A judgment without reasons is no judgment. An award without reasons is no award. Maybe an award is passed mostly by judges who are very senior, a retired judge, a senior lawyer. They will have command over the language, and therefore they may write precisely what a youngster may take something. That's all the difference.
Sir, in a judgment, there are errors contrary to the plaint or some earlier order passed by the court. This contrary, there is a error in the judgment. Can that be an application be filed to correct that judgment?
151, 152, 153 speaks about arithmetical corrections, clerical mistakes. It does not have any effect on the judgment. That could be correct after the judgment. 151, 152, 153 of Civil Procedure Code.
Yeah, CPC cases. Sir, is it sufficient for the defendant to deny the plaint, or should the defendant file documents also? And is there implied burden of proof on the defendant is the question.
Plaintiff has come to court. He has made an allegation. If the defendant specifically denies that allegation, then the burden of proving that allegation is on him. But if the documents are there with the defendant to show that what the plaintiff is saying is not correct, he can disprove his case. How will you disprove his case? Only by producing your documents.
Two more questions, sir. Whether admitted fact still required proof by documents? Admitted
left to the judge. Left to the judge. If he says, I am not satisfied, definitely, I'll give you an example. A plaintiff is filed saying, Vidhan Sauda is my ancestral property. Defendant says yes. He said, show me where did you get this?
Last question, sir. So, is it compulsory to follow CPC by the tribunals and forums?
That's what I said. There is nothing wrong with the tribunal. You blame the tribunal. No, everybody is following CPC. There is no other procedural law in this country. You are not following the procedure. Procedural law is something, what is followed in the court is totally different. And blame is on the CPC. That's why I gave you the example. Look into the latest Commercial Courts Act. Look into the Arbitration Act. For the first time they have said, hearing should be day-to-day trial. From where did I get it? It is from the CPC. 96 is the Arbitration Act. Commercial Courts Act is 2015. In CPC, 1976, they have said it. Nobody has read it. Nobody is following it. Blame the CPC.
Thank you, sir. Thank you very much, sir. Over to Varsha.
Thank you, sir, for answering all the questions. I would also like to extend my cordial thanks to Mr. Madhusudana Reddy. Friends, Albert Einstein says, life is like riding a bicycle. To keep your balance, you must keep moving. With this thought, I, on behalf of the Karnataka State Bar Council Law Academy, extend my heartfelt gratitude to our renowned dignitary Hon'ble Justice N.Kumar, and sir will be enlightening us on the topic, Regular Appeals under Section 96, read with Order 41 of the Civil Procedure Code 1908. I would also like to thank all the members of the Karnataka State Bar Council, trustees of KSBC Law Academy, guests, advocates, and all the participants who are continuously supporting us. Have a delightful evening. Thank you all.